and welcome to Legal Affairs. My name is Diamond Liddy, and I'm the public defender for the 19th Judicial Circuit. We have a terrific show, and we're going to be talking really about legal affairs today. And with us, we are honored to have the Chief Judge of the entire 19th Judicial Circuit, Lawrence Merman. Welcome, Judge.
Thank you.
And before we talk about some of the important things that are going on in our entire justice system, let's talk about you. You give us, let's start not from the day you were born, and let's go back to your education, where you grew up, those kind of things, and then I want to talk a little bit about your service before becoming Chief Judge.
Okay. I guess like most of your viewers, I came from the Northeast. I was born in New York, grew up in the Long Island City area.
Really? I didn't know. Okay.
Yes. Went to undergrad at New York University. I was an economics major, and then I decided to go to law school. I went to law school at Boston University in Boston. I was married at the end of law school, and we decided to relocate. My mother-in-law, who lives in Port St. Lucie, at the time was working for the Mets in New York, and we all know the connection to to St. Lucie County with the Mets. And so, actually, when I got married, we honeymooned in Port St. Lucie, because that was my financial
capital of the world.
Yes, it was quite different back in the day. And looked around at the area and said, well, it was such a beautiful area. It still is, but it was even nicer then. It was less developed. And we decided to relocate here, kind of on a wing and a prayer. Drove down in a Buick with everything, including the cat, in the car, and relocated here. And that's how I wound up here.
Oh my goodness! And so, where did you have your first job? Is that?
My first job actually was in a private firm in Fort Pierce, Ganano and Harrell.
Oh, okay.
Yeah, so I was working there while I was studying for the bar, and then when I passed the bar, I was applying for more permanent jobs, and I was hired by Bruce Colton, who's currently still the state attorney.
Right.
That was 31 years ago in 1989. So it was my first job, was there. As you know, I stayed there for 16 years, and I became a judge in 2005, and a circuit judge, and I remain a circuit judge at this time.
And you were actually appointed, correct?
That's correct.
Okay. And you've been a judge for how long now?
16 years, or no, 13 or 14 years, yes.
Wow. And Chief Judge for how long?
Chief Judge for a year. And what a year it has been.
Yeah, be careful what you ask for, right?
Yes.
Oh my goodness.
What a year it has been.
Now, wait a minute. You've only been Chief Judge for a year?
Yeah, it'll be a year July 1st.
Wow. I thought it was long. Well, with everything that's going on.
Seems like 4 or 5 years the way this year has gone, but it's only been a year. That's correct. Yeah.
So, okay, let's start with the system in general. The system, of course, you oversee as Chief Judge everything in the 19th Circuit, correct?
Yes, basically. So the actual function of the Chief Judge is very hard to explain to people. It involves so many things. One of the things that it involves is assigning the judges to different positions within the circuit. If they're a county judge, they must be within the county, but a circuit judge can be anywhere within the circuit.
Right.
That's one of the things. All administrative matters, fall under my decision making. We do have a trial court administrator that works closely with me. But so, the judges have complete control over what's in their division.
Right,
and
right.
how to do their job.
So they're autonomous in a sense.
Yes,
but
and people often confuse that. One of the things that chief judges routinely get is we'll get letters from the public complaining about what a judge did in a particular case. And we have to clarify, I'm not the appeals division for that judge's
Right,
decision.
right.
His or her decision is, I have no control over that. They have complete control over that as far as individual cases are concerned, But as far as procedural things, jury management, things like that, broader administrative issues, that falls under my control. And having 4 counties, as you know, because you're in the same position, is quite a challenge there too. So you're dealing with 4 clerks, 4 sheriffs, for just about
Everything.
for bar associations,
For-
on and on. And,
Right.
and each county, as you know, can be quite different.
Each county is quite
Yes.
different. And just so our viewers know, and some people are pretty good about watching this show a lot, but the 19th Circuit is, to recap, is made up of St. Lucie County, Indian River County, Vero Beach, Martin County, and then, of course, St. Lucie County, which is all of Port St. Lucie, Fort Pierce, etc. So it's a wide area. But going back to what you just said, oh my goodness. I mean, I think that is one of the most challenging things of being the public defender for the circuit, is that it's not just 4 different areas with some maybe different economic challenges or those kinds of things. Each circuit is vastly different, and they think differently. And it's just, as we've said before in private conversations, some of all of this is just herding cats, and it's not easy. It's difficult. But let's talk about what's at hand. Now, do you have an assignment, Judge, or you
In
just
addition to being chief judge, I do handle probate matters in Martin
okay.
County. So I'm the probate judge in Martin County.
Okay.
And I do mental health court in St. Lucie County, which in ordinary times leaves quite a bit of time to be chief judge, and it works out quite well. With what we're going through now, these are extreme times, and most of my time is taken up currently dealing with the COVID crisis and how the courts are dealing with that, much like all other businesses and
Right.
Government functions are trying to figure that out, but especially the court system. You can imagine with the court system, the issues that we face are daunting, including the number of people we have going through the court system,
Well,
the importance of the court system. So it has to be there, yet it presents a challenge with COVID, especially jury trials, which will be hopefully resuming next month. That's going to be a huge challenge for us, but it really highlights the challenge that we face. If you think about one thing in society that creates a challenge under COVID, jury trials would be
Oh my
right at
gosh,
the top
yeah.
of the list. People together, yet essential to our Constitution. And through this time, I found it very interesting. As you know, getting people to want to serve on juries has always been a challenge.
Always been
a challenge.
Right.
And it's very unfortunate. I spend a lot of my time talking about that issue in regular times. So now we have on top of that this crisis, yet through this whole thing, it's amazing there's an underlying implicit commitment that the public has to the right to have a jury trial, because no one has suggested that we
Do away
cut
with
that
them.
off, even
Right.
temporarily, which
Right.
I really find fascinating because of the degree of the challenge.
Well, because
Yeah.
how many times do you have people that call, I get calls all the time. How do I get out of jury duty? I don't want to do this. This is going to take all my, and you think that people don't find it important, but what you're saying is when the rubber meets the road,
Yes.
and people, it might go away or be
Yes.
continued or whatever. Whoa,
Yeah, when push comes to shove.
It's
Which is
important.
push has come to shove.
Yeah.
I mean, I can tell you that. Push has come to shove. I've never, in all of my years, 31 years in the judicial system, and you have slightly more than I do. I cannot think of any year that has been more challenging for the whole judicial system than this. And we have seen things that are happening that we've never seen before. Hopefully we'll never see again. But it's just been completely remarkable. Every day is a new adventure, you know, for me and for you.
I can't even imagine.
Yeah,
I can't. Well, let's back up though.
That being said, things are going well.
And they are.
Yeah.
And we need to talk about that too. But let's back up. We're in the pandemic, but June 1st, at least in this circuit, we opened up with protocols and rules, et cetera. Is that
partially
yes,
open? Very
up.
Partially. Too.
Okay, and explain what that partial opening June 1st was.
Yes. Yeah, well, if you go back to when we were in what was called Phase 1, now it wasn't called Phase 1 at the beginning of Phase 1 because we had no idea what direction we were going. But if you can imagine, that was a virtual, complete shutdown of everything except essential functions.
Yeah.
And even then, a lot of what we were doing was remotely done. So we have transitioned. Phase 2 involves partial reopening. So if it's a non-essential type of a hearing, you can conduct it in person to some degree if the judge, if he or she feels that they need to. They need to because of a constitutional challenge or because it just cannot really be done properly remotely. So that's opened the door for a little more in-court traffic.
Right.
But if you were to look at all of our courtrooms, which I do, I watch them all to see what's going on.
Well, you can remotely too, can't you?
Well, for most of them. For the ones that are recorded. For some civil proceedings that aren't recorded, I can't. But I do check on for that purpose to see, you know, how much is being done remotely. So, like for instance, our family division, which has more cases than any other division. I think it takes up like 40% of our total work. All of that is being done remotely. It's remarkable. We have one judge, I recently looked at their Zoom hours, with the amount of time they're spending on the computer by Zoom. Zoom is the program by which they do remote hearings.
Right.
We have one judge that in a month did over 4,000 hours on Zoom, all with hearing time. 4,000 hours.
You're kidding.
It's like having a complete courtroom remotely. And I credit our judges for that. They've been great as far as adapting to this new way. But we have other divisions in criminal, since you're the public defender. Criminal's the opposite. It's the much more challenging area because of constitutional issues. There's very little that could be done remotely.
Right.
Usually the defendant has to be present, physically present, and that creates a challenge. It creates huge challenges, the right to confront witnesses and so forth. So for criminal proceedings, we've been able to phase in more in-person hearings. For instance, even when you think of hearings, people think of adversarial hearings with witnesses and testimony. It doesn't even have to be that. It could be arraignments or a docket sounding, you know. So for arraignments in particular.
And explain what an arraignment is.
What an arraignment is, someone gets arrested, and at the very early stage of the case, they need to go before a judge to get a lawyer appointed or to declare whether they're not guilty or guilty, as people would see in the movies or on TV. So the challenge for that is most of them who have bonded out don't have an attorney, so there's no attorney to be a contact, a go-between to say, you know, what's going on. If they don't have the public defender. So that person needs to appear in court. So you'll see now there are many more arraignments going on where the person comes to court.
Right.
We have put in place protocols, which you've been involved in. We had a local work group to come to an agreement on that, to put in place. And it's things that are happening in many places, just as we're in a county building here, same thing as when we came in.
Right.
You know, there's a questionnaire process, there's temperature screening, face masks, and social distancing when you get in the courtroom. So we have gone into phase 2, which is, it's a baby step trying to get us back to where we were, but we're far from that. And I'm very happy to say, though, that because of the judges and their innovations, a tremendous amount is being done remotely as we can. But as I pointed out, it's different in the different divisions.
Well, it's just it's astounding to me, honestly, how much was done even before we got to phase two. I mean, you said, you know, as you indicated, only essential functions were allowed to be conducted, but there are first appearance hearings, which is the hearing that if someone's arrested and they're in jail, they go before the judge. The judge tells them what their charges are, sets bonds, those kinds of things. You have those are essential. They have to have those. Christmas, New Year's, Easter, Hanukkah, you know, every day of the year, and even during this pandemic. So that happened, but even during that phase one period, and certainly now, as you talk about in phase two, people have come together, the judges, the civil attorneys, public defender, state attorney, law enforcement, clerks, and made this happen. And I'm here to say that having, been involved, with the Public Defender Association and doing remote meetings for, statewide, we are absolutely cutting edge on that. I mean, there is no question we are doing more than any other circuit I know of during this crisis, which is incredible, and not risking people's health and safety, So, but okay, so we're in phase two right now. There's another looming date which you mentioned before. I guess it's July 17th, is it? When the Chief Justice is hopeful that we can have jury trials. Oh my goodness.
Yeah, just to give the viewers an idea of how dynamic this process is. It's 9:25 on Wednesday. And it was just right before I went to bed last night, I was reading the series of orders that came from the Florida Supreme Court with that question in mind. Are we still on track where we were? So I don't have a definitive answer to that because I still have to digest what I've read. But my understanding today is, yes, we're still on track to restart jury trials mid-July. However, we would be remaining in phase two for that time. And there will be a procedure in place to allow jurors, to excuse jurors. This has been a big issue from the beginning because jury service, as you know, is compulsory and people face contempt if they don't show up. So it's not like deciding to go to Home Depot. You have to go when you're summoned.
Right.
But what we have done, we did this on our own in our circuit, but the Florida Supreme Court has even gone beyond that to allow jurors, under the penalty of perjury, which is what I read last night, to attest to certain facts that would allow them to get out of jury service, particular COVID issues. One of them that you and I had come to in our work group was if you're in a high-risk group,
right,
and you can't focus,
right,
and you can't operate as juror because you're worried about contracting the virus, regardless of the scientific facts. If it just plays on your mind because you're in a high-risk group,
well,
you'd be able
over
to
the age of 65, right?
Right, you'd be able to opt out if you have underlying health conditions or in an elderly person. But this goes even beyond that. This relates to child care and whether you lost your job and got a new job. So they're very particular to where we are in the country, given this unique circumstance. And I think the statement there from the Florida Supreme Court is, we want to continue with jury trials. This is part of our Constitution. It's very important. But we want to be sensitive to people and not put them in a position where we're causing them undue anxiety at the same time. Now, let's hope that it works. Because let's hope that it works, but like everything else we're doing, we are giving it our best shot. The Chief Justice of the Florida Supreme Court has been working. We've all been working overtime.
They have a work group, too.
They've all been working overtime, and we're all giving it our best shot, and hoping that it works, and trying to remain flexible. You mentioned too, we're in phase two. and hopefully we stay in phase 2. Hopefully at some point we
Yeah.
get to phase 3. They're actually working right now to determine what will be the criteria to allow us to go to phase 3. They aren't set right now, so we don't
Right.
know what those criteria will be. And we all know, we've discussed many times at all levels, the situation is dynamic. We're all, hoping and praying that it gets better and we keep moving forward, but we have to be vigilant to be sure that it doesn't get worse and we go back. And as we sit here today, in the last week or so, we're all concerned with that, and the newspapers
Oh,
have
yeah.
spoken to that, and we monitor that. One thing, the trial court administrator and I were in constant contact daily, if not multiple times a day, with our county health departments. At a minimum, we get alerts, email alerts as
Right,
far as the
right.
status check, and then on occasion we'll talk to them directly and say, what's your assessment? Because the situation, I
Is
think
so
people,
fluid.
it's not only fluid, it's complex. There's not
Yeah.
one statistic you can look at and say, oh, that it's getting better, it's getting worse. Look at that one statistic. You have to
Right.
put it in place. And the Department of Health is the Department of Health. It's interesting because the judicial system functions one way, but and then there's the governor's role in the Department of Health as it relates to the governor. There's the societal reopening, and from the beginning, I've thought at a minimum we should be in line with what the governor is doing. We don't
Right.
want to be beyond what is going on in
right.
society is what the governor has dictated, and you can imagine the challenges that the governor and his staff are facing, statewide as far as reopening society, the economy, and so forth, and generating revenue so that we can function, so we can all function, while protecting people is an extremely difficult balance.
Well, and it goes back to the basics of our Constitution. I mean, the governor's role is autonomous and separate from the judiciary's role, and Justice Kennedy can do something totally different than now. Not that they would, but that could happen. I mean,
It could happen.
And
yeah.
and then what do you do as a chief judge of a circuit? And I just can't. Well, and the other thing is, and of course we could talk about this for a whole show, and I can let you kind of give a short Reader's Digest synopsis if you can, but the unprecedented tolling of speedy trial. I mean, speedy trial, so our viewers can know, is a rule that basically, make sure that someone accused of a crime doesn't languish in a system and just do 10 years in jail while we're figuring out whether or not we should bring them to trial or not. It allows for a speedy trial to be had if you're accused of a crime, and the Chief Justice told that.
Yes.
And
which
that's
got even more complicated if I read correctly last night. There has been a change on that
really
as well. Yes. The previous, there again, this is my reading from 10:30 last night.
Yeah, I know.
while
I
was
haven't even gotten a
while I
chance
was
to read
falling
it yet.
asleep. But if I was reading it correctly, before last night, it was that speedy trial was told until a date in July. I think it was
right.
a date in July.
Right.
Now, I believe it's told until when we go to phase 3. So, yes.
Whoa, so they've
and then
extended it even further.
And phase
Whoa.
3
hasn't even been
is
determined.
different.
Yeah.
Will be different in every circuit. Because phase 2 has been different in every circuit.
Wow.
So that means that date will vary.
So your speedy trial rights in the 19th Circuit could be different than Dade County,
Yes.
than
Yes.
Pinellas.
Which was,
Wow.
which is
Huge.
interesting because that was an acknowledgement that it's dynamic. Not only is the COVID situation dynamic,
Yeah.
it also differs from place to place within the state, which, the public can see Miami and Broward is a different circumstance than in more rural places, and we're sort of in between. But the reason for all of that, the reason for the extension of the speedy trial rules to allow us to function without having jury trials. There's one state in the union, I think it may be Oregon, that does not have within their state laws the ability to do what the Chief Justice has done here, the ability to toll it. So during this whole COVID crisis, there's one state, which I believe is Oregon,
No
that's actually
kidding.
had to have trials. And they've suffered the consequence with that. If you imagine if you had to do that, you're endangering people at a very early stage. And we all know the science is dynamic, the science changes, and the protocols change based on the science. When we first started this, I think, at least from my perspective, we were all washing our hands 10 times a day, and we were told masks didn't matter. The science has completely come around there. Now masks are much more important than hand washing based on the science today. And I'm not saying that critically. I mean, they're doing their best to understand the virus.
They're figuring it out.
They're figuring it out, and we're going from there. When I say you and I and the rest of our work group, which has the sheriffs and the clerks involved in the 19th Circuit, when we created our protocols for coming into the courthouse, I remember specifically thinking, well, should we require the temperature screening, because at that moment
it wasn't the end-all be-all.
Right, because at that moment we believed that the majority of the spread of the virus was from people who are asymptomatic, who weren't showing symptoms.
Right.
So what difference does it make if you take their temperature?
Yeah.
Well, then just a few weeks ago there was this big article that caused so much stir about the CDC, or the World Health Organization, said, it doesn't appear that asymptomatic spread is as a big deal as we thought before. So you would be symptomatic. So then doing the temperature screening turns out to be might be the most important thing that we're doing. So it gives you an idea what we're dealing with and how dynamic it is. So we're all doing the best we can to protect people, but just like everything else, just like businesses functioning and schools functioning, we have to go on. We can't stay behind. And another issue that has made people that has caused thought is how important the judicial system is. Question mark. How important is it really? And the truth is, it's very important. And not just with criminal cases, but with civil cases too. People need to have a way to address their grievances or to settle their differences in a civil way. And that's the function that we perform. And when you take that out, it can be very scary as far as what happens generally with society. So we hope to be helping that situation as well by restarting the judicial system or keeping it going. It is that important.
Oh, no. And believe it or not, we're out of time. We've got about 30 seconds, but I do want to say, hats off to you, hats off to all the whole system who has worked together, as we always do in this circuit, to make things happen. And the good news for the viewers and who are watching it is we're still working and we're still taking care of business, and things are not going to languish, and things eventually will get better.
Let's hope. Yes.
And thank you, Judge, so much, and keep up, the really great work.
Thanks for having me.
Okay.